Good morning, good morning. Good morning, everyone. Welcome back to another session forming part of our webinar series, How Not to Drive Your Business to Zero, but actually set yourself up to thrive in the aftermath. Today, our host, Deirdre Watson, Director at Vertex IT Services, and our guest, Deirdre Watson, Barrister and Mediator. Once again, before I hand over, a few important notes. Recorded version of this webinar will be available on our social media. Should you have any questions, please post them in the chat and we will address those at the end of the interview. And then you can also have a look at our upcoming interviews and the dates on our registration page, and also follow our socials for that. Okay, that's it from me. So, Daniel.
Great stuff. Thank you, Bianca. Deirdre, welcome, welcome, welcome. Just for full disclosure, in case somebody hasn't already figured out that our surnames, we're not married. My wife has previously been on here and she's taller. Deirdre is my middle sister, but also the smallest one, but that's okay. I ate all my Weet-Bix.
Good things come in small packages.
Yeah, but the boat I want for my birthday will not come in a small package. Okay, so Dee, thanks for coming on and doing this. One of the other things that people don't know about you is that you also lecture at the university. What's the course that you're lecturing at the moment?
It's Common Law 304, and it's a paper that deals with business obligations, and I lecture the franchising segment of it and the joint venture segment of it. And ironically, as I was about to start my little stint, I have 14 hours that I do, the lockdown came in, and so the university was in turmoil initially, trying to figure out how the learning was going to be delivered to students, and that's basically been done by pre-recorded Zoom meetings, which then get uploaded to the university's media publishing storage house, and students then download it into Canvas, and students then get to watch it. So it's actually working really well. It's quite a different way of lecturing because you can I've been able to sort of sit down and basically pre-record the whole 14 lectures in, over a couple of days, which means that you can remember things and it flows a lot better. Whereas previously it's done 3 hours a week in a sort of more disjointed way.
Okay. Did you get any coaching on like how to deliver a lecture series via Zoom or anything like that, or kind of instructionals?
Yeah, yes, it didn't sort of happen straight away, but in that week that universities had I think a week off back in the week following the 25th of March, the university just pulled together a whole lot of resources, and they've got quite a good help desk situation going on, and they ran their own sort of webinars, but obviously a lot of lecturers were trying to grapple with it because not a lot of lecturers had previously used Zoom. A lot of businesses had been using Zoom for quite a while. I knew about it, but then to sort of integrate it into the university system was a whole other nightmare. But once it's up and running, it was good. A little bit hit and miss. So some of the lecturers one of my co-lecturers, he just finished his lecturing segment, so he was, quite relieved not to be involved in.
No, because there's ways that you can enhance the experience over what you'd normally. Like, I mean, some of the worst lecturers that I remember at university was like, mechanical engineering chap who faced faced away from the entire student lecture theatre and spoke at the whiteboard the entire time in a monotone, just drawing this out, and you just tried to keep up with the notes, and it was you'd end it like you just ran a race with him. And then straight afterwards, he'd disappear. There'd be no chance to ask questions or anything. They'd be gone. Like, whoa. So, yeah, I'm glad you got this opportunity to make it work better for you than, the 3-year format. So, okay, the standard question that I'm asking everybody that comes on this show is, what's the biggest mistake a business owner might be making legally, or has probably already made right now?
The biggest mistake they're making legally. I think one is probably not just sitting down and looking at all of their contracts and reviewing them. A lot of people have kind of got their heads around the lease situation now, and they know that you've got to look for whether or not there's a no access and emergency clause. And so they're using that, and people have sort of worked out what that means. But of course, there are many other contracts that businesses have that they're a party to that, you know, they may or may not, you know, still be required to perform their obligations under those agreements. So I think, you know, most businesses, what they should be doing once they've kind of got their heads around, you know, do we hibernate our businesses, or do we find a way to keep going? As part of that exercise is really reviewing all of their business agreements, anything from, you know, photocopier agreements or other kind of supply agreements that they might have. And the work that I do, a lot of those agreements obviously include franchise agreements. And those kinds of agreements can often have clauses in them that excuse one or the other parties from further contractual performance.
Right. Just going back a step, because you say most people will be aware of this, but, you know, startling statistic that I keep on bringing up is that half the population of the nation is of below average intelligence. So not necessarily everybody's going to be aware of it. Not being mean. That's just actually, think about it, it's a statement of fact. So what is that clause you're referring to?
The no excess and emergency clause.
Yeah.
So that's a clause. Did you want me to I've actually got I can show it on my screen if you want.
Do you want to do it on your screen? I can share that presentation out you gave to me, or?
Here it is here.
Yeah, you go.
Yeah, so that's the clause. It's typically in an ADLS, Auckland District Law Society clause, and it's clause 27.5. And essentially what it means is that if due to some government restriction, like we've got right now, the government's restricted people from accessing premises, if because of that restriction you can't get access to your premises to fully conduct your business, then the rent has got to be reduced. A fair proportion of rent and outgoings have got to be reduced. And so a lot of people who've got these leases, we don't know how many people have got leases like this, but somebody suggested about 20% of commercial leases around the country have got this clause in them. A lot of people are getting together with their landlords and trying to negotiate a fair rent reduction. And the ranges of reductions that we're seeing are between 20 to 80%. Fair means fair to both parties, so bearing in mind the landlords.
That's a bit cool, because I've heard people saying they've just sent a letter to the landlord saying they're not paying anything. Yeah,
well, those sorts of people aren't very realistic, because ultimately they're going to have to pay something. You know, whether it's 20% or 30%. Really, what's fair boils down to the type of business that it is. So if it's a business where you've actually got to, like a cafe, for example, where you need to have, you know, premises in order to generate revenue, then, you know, the reduction is going to be a lot more substantial. If it's a business, for example, you know, like a business that can continue to run without premises because you can meet with people over Zoom or Skype or whatever other platform, then obviously the reduction should be a smaller amount. But the thrust of the clause is really directing people to negotiate. And if you can't reach a resolution, there is the ability to go to arbitration, and the Auckland District Law Society has a property subcommittee, and they're putting their hands up and saying, well, for $200 we'll give you a declaration as to what the amount should be. So there's lots of pathways for people to basically negotiate a good outcome there. But if you haven't got a no access to emergency clause, you are really reliant on another type of clause that might be in your lease. And a lot of people who've got these sort of big bespoke leases, like the, you know, the Centre Group ones or the Kiwi Income ones, or, you know, whatever else, one of those sort of big property owning entities, are really looking through their leases to see whether they've got a force majeure clause, which in essence is a clause which enables you to get out of further performance if certain defined events take place. And it really, every single force majeure clause is different. You've got to sort of scour through your agreement to see whether you've got something like this. And what I've said to people is just look for a clause, read your agreement thoroughly, look for a clause that says in the event of a significant event, certain consequences apply. It won't necessarily be called a force majeure clause. It might be called a no obligations clause or a release of obligations. And every clause is going to be different. They're not really boilerplate clauses like the no access and emergency clause. And sometimes they only apply to one party. which is not very nice, but not very helpful, but unfortunately that's the case. So you've got to really go through your agreement to see whether you've got a clause like that. And if you haven't got a clause like that, you're looking at whether or not the contract itself has been frustrated. So whether or not you've met the tests for what we call legal frustration. And that's a doctrine that says that if the whole object of the contract is now frustrated, then the parties are released from their obligations under the contract. And a lot of people, at the beginning of all of this pandemic, we're going, oh great, we're going to be able to say that our contracts are frustrated, but it's not as easy as you think. It's actually quite a high standard to get to in order to be able to demonstrate that a contract is legally frustrated, because you've got to say the whole agreement is frustrated. So for example, if you've got a lease that's got 10 years left to run, and we've got a pandemic that is going to mean that you're going to be out of your premises for say 3 months, then the whole agreement hasn't really been frustrated, just a small part of it has been.
Oh, over the term as well.
Yep.
Right.
Yeah. There are a couple of cases that talk about partial frustration, but that's a sort of, I guess, going to kind of apply maybe in a particularly unusual situation. So again, it's really a case-by-case situation, and it's quite important to look at the circumstances of the lease and the business. Has it got 10 years left to run? Has it got 10 months left to run, in order to work out whether the whole contract itself has been frustrated. This last bullet point here is, so level 3, 4, 3 and 2 won't necessarily frustrate the whole contract.
Right, because they can show that you are potentially able to start trading again and use the premises. You're not being held out from doing so that wouldn't apply.
Correct.
Although that could depend upon your business. But if you go down that path, right, you're kind of basically saying to your landlord, no, we want out and be gone, right? And if you're going down that path, is there a way back from that? I mean, kind of sounds like it's a final solution.
Well, not when you say if you've got a contract with somebody and you say to the other party, I'm not going to perform my obligations under this contract anymore because I think it's been frustrated. And say you said that and you actually didn't have grounds to say that, because in actual fact, the tests for legal frustration weren't met. Then what the law says is that you are repudiating your agreement. Sorry to throw in some technical terms here, but it's important for what I'm about to say next. So the law then says, okay, you've wrongly said you don't have to perform your obligation, so you've repudiated your agreement. That then gives the other party the right to cancel the agreement. And you might think, great. Again, you might think, great, they've got the right to cancel, so they might cancel. But that's not the case, because when they cancel, you are then in the firing line for a heap of damages. So if you said, okay, I'm not going to pay any of my rent anymore under this agreement because I haven't got a force majeure clause, I haven't got a no access as an emergency, but I can't get into my premises and I think the whole lease has been frustrated. I've got a 10-year lease or whatever. That's probably going to be a repudiation of your lease. The landlord can then cancel the lease and sue you for damages, which might mean all of the rental payments for the full 10 years, or all of the rental payments that you would have to make until such time as a new tenant was found. Once they've cancelled, there's no going back. So they cancel, and then you go, oh my gosh, why did I do that for? I should have just stayed there because we're now out of the pandemic now. I should have just kept on trying to trade my way out of it. It's too late to go back. So you could be in a situation where you're sitting there, you actually want to get back into your premises because it's 6 months down the track and you're sick and tired of getting these bills from the landlord saying you've got to keep paying the rent anyway. You've got a business that you would have otherwise been able to operate, but you can't go back to your premises anymore because you've lost them, because you repudiated, the landlord cancelled. So all of these, this is why I say in this slide, there are a lot of risks in treating agreements as frustrated when they're actually not. So you've got to tread very carefully in negotiations. Yeah. I'm aware of those sort of people that are out there saying, well, I'm not going to pay any more rent. And I think a lot of franchisors have done that. where they've got the head leases in their name. They've got the head leases for 30 leases around the country, and I know there's a couple of big restaurant chains around the country that have done that, and they've said, no, so we're not going to pay any rent at all. But they're risking at the moment mass cancellation, and some people will say, well, are being very confident, saying, well, landlords aren't going to do that because they're just not going to go out there and cancel a whole lot of leases. But fast forward 6 months, they might do that because then they've got all these leases of these quite well set up, restaurant businesses with all the fit out that's in them in good locations.
Yes.
A lot of quite good restaurants are in quite good locations with all of the goodwill associated. People are going to start going back to restaurants or whatever in 6 months' time or however long it takes. We're going to recover eventually. Yeah. And then, those business owners have lost the cash cows that they had. So, I don't think that landlords are going to necessarily be sitting there thinking, we're not going to cancel. They might see it as giving them a business advantage. They might see it as a way to leverage more money out of the tenant. So there's a whole lot of reasons why commercial landlords might not be hesitant in cancelling, because they've got guarantors. End of the day, they've got guarantors and people that have got homes. Anybody that's signed a lease, that's got a home, is going to be worried as well because their homes could be sold. So there's quite a lot of I think risks in treating agreements as frustrated when they're not.
Yeah, I mean, there was a reason why McDonald's bought Georgie Pie, and I think the Green Lane position was right up there, wasn't it?
Oh yeah, you're right. I've forgotten that Georgie Pie was once there.
Yeah. I mean, it was an awesome spot, and they still chuck out some pies from time to time. But so realistically, if you don't have the clause, the 27.5 clause, which gives you a way to talk to your landlord into negotiating a way, then there is the frustration method. But the legal frustration method, it can be extremely risky. I mean, it sounds like you have to do some careful gaming of potential outcomes and figure out what is the least painful path, if that's what you're looking like. Because it sounds like, wouldn't it be easier if it's looking that serious, winding up the company would probably be a better plan, because then all the obligations would go with it. Is that right? Or have I got that wrong?
Yeah. I think sort of maybe the accountants that I talk to say that, look to hibernate your business, look to get your costs down as much as you can and just go into hibernation. I mean, the only thing about liquidating a business is that if you're on the hook personally as a guarantor for any of these obligations, then you're kind of, in a not very good position, really. So liquidating a business is probably not going to be a good idea because, again, that's an irretrievable step. And if you're going to get called up under your personal guarantee, then it's not really going to matter that your company's in liquidation.
Yeah.
But it is risky, and all that lawyers are doing is really, I guess, saying to people, well, just be aware of the risks and doing that, because ultimately, it could be a mistake. And people that have got multiple leases that are probably more of concern. And I know a number of franchisors have got multiple lease situations going on at the moment, and they're experiencing a range of different reactions from landlords. Some landlords are going, okay, look, that's no worries at all, pay 20% of the rent. And other landlords are saying you need to pay the full rent amount tomorrow. So that's just a hugely worrying situation. So yeah, you're right, but you're quite right. If you've got the clause 27.5, you find you're at least going to be able to. You're going to have to pay something, but it's not going to kill you. Hopefully, if you haven't got clause 27.5, what you've got to hope for is that the landlord sees you as a good prospect, sees your business as a good prospect, and wants to hang on to your business maybe, and knows that they just need to help you weather the storm. If you've got a good landlord, if you've got a landlord that's not good, it's not a great situation to be in. And all you can really do there is look for ways to hibernate, and which sadly is going to mean that employees are going to lose out, because people are going to. That's where you get into this mass redundancy situation. Employees are going to be the next step to go, I think.
Yeah, and if I'm all for business optimism, because the more people that are optimistic, the more likely that people are going to push forward. So doing the best that we can to keep things working is best for the country. But there comes a time where you have to, you know, make sure that you've got it planned out with your accountant and your lawyer to make sure that you are treading the right path, because it is complex and you don't want to just barrel ahead and go it blind. So I was just thinking, going forward, like you know, people have got other kind of contracts out there, like I don't know, such thing as like the photocopier agreement and waste disposal bins and that kind of stuff. Have you got any advice for people who are working with people like you know, RICO and you know, waste disposal, etc.?
Yep. I think again it's a matter of getting a hold of your agreement, and you know, it's amazing at times like this that people can't quickly access those kind of contractual documents, because typically when you sign up for a photocopier, for example, you know, they shove the form under your nose. There's a whole bunch of fine print, and sometimes you sort of don't even think you need to look into the fine print. But try and grab a hold of the contract before you do anything. Have a look through it. Try and see whether there's a force majeure clause in there, or anything that says that in the event of an act of God or a pandemic, or some other restriction, that the contract is at an end. And if you've got that clause, which you most likely won't have if it's a photocopier contract, because a lot of them are they're drafted by the photocopier companies, by big law firms, and they're very well protected in terms of the photocopier companies, but you tend to have minimal rights under them. Look through the agreement, scour through it, see if there's anything at all that helps, and then act accordingly. I mean, a lot of lawyers are out there saying you've got to get legal advice and all of that. Yes, in a way, it's good to get legal advice, but most people can read and, you know, use the common sense.
If you've got one of those big box copiers sitting in the corner of your office, if you're near renewal time, be really careful about because what often, actually, Daniel Silver is here from DSL Logistics, and I know a few years back they had their photocopier was saying, hey, you're going to be getting, we're renewing all your photocopiers. Oh yeah, okay, cool. Turned out it wasn't so much they were just sending them new photocopiers because they had kind of come to 3 years and it was time for a refresh. It was, no, at 3 years of a 5-year lease, they were saying, sign the renewal agreement at 3 years for another 5 years, and we send you new copiers now. And that was a time where I think I gave them some advice, because often we'll just sell appropriate printers at a reasonable price, and then you know, the ongoing services, support and provisioning is taken care of. But the thing that really gets me is on those is that they often have minimum page counts and that kind of stuff, which lock you into a certain amount of usage. Now, it's fine if you're in a big office or a warehouse where you're pushing a lot of invoices and papers, dispatch notes out there, but I see these big box printers in offices with like 4 people in it, and I'm going, that's like a $12,000 machine. How many print jobs do you do per month? Did you know you can go almost paperless?
Yeah, I don't know, it's a bit of a hangover, and I mean, in our industry, you know, a lot of stuff is still by paper. And when we prepare and print out our case books, you know, they can be reams of paper, you know, several East-like folders long, and everyone has a copy. So you're doing a copy for this and a copy for that person. So we have these big jobs, and we send them down the road to Snap Printing, but we still do some of them in-house. And, you know, you need to photocopy a 200-page affidavit or whatever. So the quickest way to do it is just to throw it through the photocopier machine. So we have one of these. It's you know, it's big. It sits in the corner. You know, a month can go by, I don't necessarily use it, you know, but then a month goes by and, you know, we're using it a lot. So we've got to have it there, and we have to have it for an emergency. And they love to do, you know, photocopier companies like to have these renewal agreements. But we had a massive fight with our photocopier at the beginning, because, you know, the modelling is that the sales person comes in, they talk the talk, you know, you say, yep, you trust everything's going to be fine and okay, and then the photocopy arrived and we realised that we'd been sold something that was just way beyond anything that we would need to use. We just didn't need anything that huge and that massive, and it was, you know, charging us for being there basically in the corner of the room. And so we were able to negotiate an exit from that, and we got it replaced with a smaller photocopier. But I think that that was one of the first things I looked at, because we're paying for it at the moment, and we've got another year or so to run. But, you know, the photocopier companies have got to kind of change their modelling really to monthly, because a lot of people like me are going to go, well, when the agreement comes to an end, I'm going to be sitting there saying, well, I'm just going to send everything now to snap printing. There's no point in having any photocopier here, because my printer can do some quite good copying if I need anything copied.
Yeah. Is it, how did you go with your negotiations with your photocopy company?
Well, I haven't actually approached them in the light of the pandemic, but when we had that big problem at the beginning, the negotiation didn't go well, because my business partner is a lot more aggressive than I am, and my business partner, Paul Dalkey, and I had to step in because I could see it was going south. There was a lot of cussing and all kinds of allegations flying all over the place.
Yeah.
So I stepped in, and when I stepped in, I said, look, hey, we need a photocopier. You've given us a photocopier that we don't need. Let's just try and make this work, because it can be a win-win here if we just get a smaller photocopier, and, you know, you still get the revenue coming in. So we were sort of able to rescue it basically. And I don't know to what extent though they were by that stage willing to do a deal with us, because they'd been worn down.
Yeah. Is there like a cool down period for all contracts, or does it actually have to be written into the contract?
For photocopier contracts?
No, is there like a general, like under New Zealand law, like if you sign a contract and then like X number of days later you go, oh, what the, I didn't realize that was what it was. No,
there's like a cooling off provision.
Yeah.
No, there's a lot of those provisions in franchise agreements, but they really only give you 7 days to cool off. With contracts now, if they're business to consumer contracts, there is a ability under the Fair Trading Act for the Commerce Commission to declare certain provisions unfair. So if they're clauses that have got unreasonable, you know, termination clauses in them, like clauses that say that if you terminate early, you've got to pay us X sum of money, then that could be regarded as unfair. But where they're business to business contracts, then the same doesn't apply. So most of these kinds of contracts that we're talking about, like franchise agreements and photocopy agreements and other kinds of supply agreements, are business to business contracts.
Yeah, and I guess sometimes when you're dealing with other businesses, there is sometimes a bit of a blurring of those two, the commercial versus the consumer side of things, and people don't get that what they're entitled to and protections with, you know, in consumer contracts or, you know, Fair Trading Act, they don't apply in business. And
and that's where, but that's about to change, because the government's looking to bring in that unfair contract regime into business to business agreements.
Oh, really?
Okay. Yeah. So, so I've been heavily involved with the Franchise Association and making submissions and meeting with ministers to talk about that proposed change that was coming before the pandemic. It'll probably be delayed now. But what it will mean is that for franchise agreements, which are the kinds of agreements that will be covered because they're standard form contracts, the unfair contract regime will apply. So if there are unfair termination provisions or clauses that enable one party to change the agreement and not the other, then the Commerce Commission will have power to declare those provisions unfair. So that will also apply to photocopier agreements. And the only downside with this unfair contract regime is that it doesn't give you a private remedy or to set aside the agreement. It gives the Commerce Commission the right to apply to the court for an order that the contract is unfair or that certain parts of it are unfair.
That sounds expensive.
Yeah, and a lot of people are saying, well, that's not really going to help us that much, but it's still significant, and it's small steps. And because I think the thing is that the law reflects the fact that, you know, we've got agreements like franchise agreements or photocopy agreements, which they're kind of really, there's no good reason why the unfair contract regime shouldn't apply to them, because a franchise agreement in many cases is a bit like, an employment agreement. People don't get legal advice on them. Often they're massively complex documents and agreements, and they're heavily drafted in favour of franchisors. There's almost no protection for franchisees. So there's not really any good reason why there shouldn't be a law saying, well, you can't have unfair contract provisions in them. So I think that we're nearly at 11:30.
Oh yes.
So yeah, but I see Bianca's asked a question. Your thoughts on what the transition to level 3 would look like for franchises in hospitality, travel and tourism. I think that it's pretty likely that hospitality is going to still be significantly affected by level 3, because they can't really open unless they've got the ability to do takeaway. And for businesses that are in malls and big complexes like that, realistically they're not going to open again. Those kinds of businesses aren't going to be up and running again till we're down to level 2. But even then, with social distancing, we're going to be stuck with social distancing for very long time. I read a paper over the weekend. It was either Harvard Business or somewhere that sort of talked about the fact that we might be dealing with social distancing in 2022. And really until they've got a cure for COVID-19, we're just going to have to be living with social distancing. So that's going to impact a lot of businesses that really depend on being able to cram, lots of people into a small space. And the longer this goes on, the more we know about the spread of our little droplets. So 2 meters, I was listening to something over the weekend that said that if you sneeze, your sneeze powers the droplets out at 100 miles an hour. So if somebody's standing 2 meters from you, they're going to get hit with your droplets. So 2 meters, is that even far enough away?
It's a probabilistic thing. If your people are taking that kind of distancing, then they're probably not, or they're also not shaking hands and that kind of stuff, or hugging, and which is taking the percentage likelihood of transmission down from 100% to a smaller percentage, which is, hey, it's working for us. I mean, we're at the point where we're now talking about and looking at what level 3 is going to look like, what level 2 is going to look like, and people are making their plans. Is there any other questions from the floor? Has anybody got anything that they'd like to ask Deirdre? If now's the time. If you don't have any, that's fine also. We've done the half an hour, which is the target amount. How have you been finding the lockdown? I mean, have you been able to keep on trading yourself?
Yeah, I had a lot of my work is ongoing work. So, and I've got a couple of big cases coming up this year. So I've had work, to do, but there's a drop off in new work coming through. And then for a lot of the work that I had, people have now got bigger fish to fry. So they're going, oh God, we've got other problems that we've got to sort out. It's thrown up a few issues. There's a lot of franchisees out there now, wanting to walk away from their franchises. So I've got a couple of jobs like that on the go. But really I've been sort of focusing on trying to just keep busy, trying to help people out there, because a lot of clients and people that I deal with, what I was noticing initially is that they wanted legal help, but they didn't want to pay for it. Well, they couldn't afford to pay for it, because a lot of businesses have been in shock. We can't afford to pay for a lawyer. So I've sort of focused on putting a lot of help out there and just giving people information so that they can go and do it themselves. They can go and negotiate with their landlords themselves if they want to. They don't need to go through a lawyer, on the theory that what goes around comes around, and people will remember me in a year's time. Well, that was the lawyer that was helpful.
That's right.
Out on LinkedIn, but,
She said I could probably have a go at this myself. Now I actually need her.
yeah. Oh, so I acted for myself. I mucked it up. I'm going to go and have a crack at her now. But yeah, I mean, a lot of clients have been just appreciative of that, because they can, people who are company directors that have been in business for a long time, they can handle these negotiations pretty well. So yeah. What about you?
Oh well, it's been fun, but interesting. It's that Chinese curse. Hope you live in interesting times. Yeah. I think it's going to be interesting for young people, because it's going to be their first big recession. Whereas those of us who are in their middle age, you can think of 3, 4, or 5 off the top of your head. You know, once every 7 years or something like that is the, you know, a recession or depression or correction. It's just, you know, we'll get through this. Things will change. There's opportunities in it, and some dreams have to be shifted sideways or changed entirely, such as it is. Yeah, so you know, as long as you keep trying new things, you'll get success. It's when you put your head in the sand and you go, look, I can't handle this anymore, that it's stressful. But I find that communicating with other business owners who are facing similar problems, even if they're in different industries, is really useful, because they will have their unique perspectives on it. They will have access to resources that you might not have heard of, and you can share the wealth and come on through, because it will get better again. May not be in 6 months, maybe in 18 months we could be riding high on the back of another big wave of optimism, and you know, and whilst, you know, fending off the zombie hordes from the United States.
Yeah.
All sorts of things could be going on.
Turning up on the shores. Yeah.
That's right. So very good. All right. Thank you, Deirdre. That's been
No
really
worries.
cool. That was getting into some of the nitty gritty there that I think some people will appreciate. Bianca, this is the time where you come on and you tell us about what's happening next in the series.
Yes, okay. So we're still chatting to John Bishop, Professional Director, to try and get him on this week. We just need to confirm that. But until then, we've got confirmed for the 24th on Friday, Carolyn Ranson, partner and Smith & Partners lawyers. So yes, we'll add it into our social media that we are trying to get John Bishop.
Yeah.
Okay.
Now there's a couple of things there. John Bishop's on, like, if you look him up, he's on loads of boards, and I hadn't even considered the idea that people just are directors professionally, and that's what they do. They just get into loads of companies. I guess that's another level. So there'll be some interesting concepts there that he'll be able to talk about. And also Carolyn's an employment lawyer, so she'll be dealing with the sticky issues regarding if you are hibernating, how do you handle the jandal with your employees and all that kind of good stuff. So, all right, let's wrap it up there. Thank you very much for everybody coming along. We should have this up on YouTube by the end of the day, and post it around with the confirmation as to when exactly is the next one. It'll be sometime this week. I'm thinking Wednesday, but let's see. All right.
Thanks,
Good
Daniel.
stuff.
Thanks, Bianca.
Cheerio.
Bye. See you.
Bye-bye.
Bye.